Did an investor in a residential mortgage-backed security sue the trustee for failing to go after the originator of the loans? To find out, you have to read IKB International versus Wells Fargo Bank, but it's 38 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of IKB International versus Wells Fargo Bank, published by the New York Court of Appeals on June 15th of 2023. The citation for this case is 2023 New York Slip Opinion 03302. I'll attach a copy of the decision to the description. There are a lot of issues in this case related to no action clauses, breaches of contract for failing to enforce repurchase and replace provisions, and tort claims. But we'll get into that in a second. To understand what's going on in this case, you have to understand two different things. One, what an RMBS is, a residential mortgage backed security, and the second, what a no action clause is. To understand and appreciate how a residential mortgage backed security works, you have to compare it to what it used to be. Traditionally, people would approach a bank, wanted to get a mortgage. They would tell the bank, and the bank would then conduct a complete investigation, would perform due diligence to make sure that if they gave a mortgage out, it was to someone who had appropriate credit, sufficient assets and income, the house appraised properly, and if it was right, they would issue the mortgage, and the bank would hold on to that mortgage for 15, 20, 30 years, for the life of the mortgage. So they had incentive to do all the right work on the front end because they're going to be left holding the bag when the mortgage defaulted in 10, 15, 20, 30 years if they did a bad job. But in the early 2000s, people realized that you could take thousands of these mortgages and pool them into a security. And then if one or two mortgages defaulted, it wouldn't be a big deal because you'd have these big pools of mortgages and they would shoot off a lot of income. But you could also then loosen how tight you were with giving credit out and give subprime mortgage, give out subprime mortgages because there were this protection of having a lot of mortgages in the pool. But this kind of system has a lot of parties. There's the originators who give the mortgages and they're supposed to do the due diligence. Then there are sponsors who then buy thousands of the mortgages and put them in pools. The sponsors then give them to a depositor, which is a financial institution, and the depositor creates a trust and puts them in a trust. And there's a trustee. But because there's so many parties and there's such distance between the originator who did the work and the investors of the trust, to give the investors of the trust, the certificate holders we call them, to give them some measure of accountability and sort of assure them that the mortgages are actually what they say they are, the trust agreements usually have what's called a repurchase and replace provision, which allows the trustee who's in charge of the trust to contact the originator and say, you didn't do a good job here, you breached your due diligence, and I want you to repurchase or replace these bad mortgages. So that's the protection that they can sell this trust to certificate holders. That's an RMBS, a residential mortgage backed security. And the second thing you have to understand is what a no action clause is. A no action clause is a standard clause in these trust agreements that say the certificate holders, the investors, are not allowed to sue anybody in this process, originator, sponsor, depositor, trustee, unless and until they give the trustee written notice of the breach and they give the trustee a certain amount of time to do what they want done. So if they say, you should be suing this person, the trustee has a chance to sue them first. If the trustee takes no action, then the certificate holders or shareholders can sue. Okay, so what are the facts in this case? The facts are that there was a trust here, a residential mortgage-backed security, with a standard no action clause, and that clause said that you have to give the trustee an opportunity to file a lawsuit first in writing, and beyond that 25% of the certificate holders have to sign on to that before the trustee has an obligation. Then there's the 2008 meltdown, a huge recession. A lot of these RMBSs lost a tremendous amount of value. And here, the certificate holders sue their trustee. And they say, you breached your obligation to pursue that repurchase and replace ability you had. You didn't contact the originator and make him repurchase or replace these things. The defense moves to dismiss this at the beginning of the case for failure to comply with the no action clause. They say, you didn't give it to me in writing and you didn't have 25% of people signing on. Also, we don't have a duty. We had a right to exercise this, but not a duty to do it. And finally, they say the tort claims, because there's tort claims here too, saying there's a breach of fiduciary duty and there's also there's a conflict of interest. They say these are duplicative of the breach of contract claims. They should be dismissed. And that's what goes to the Court of Appeals. And here we have a majority decision and 2 dissents. The majority says, as to the no action clause argument, that cannot be a defense here. They say they're throwing that out. And why is that? Because the trustee cannot sue him or herself. So to require the certificate holders to put in writing, hey, trustee, sue yourself, the trustee can't sue himself. So because the trustee can't sue himself, to make them wait the 60 days or so for the trustee to fail to do it before they can sue doesn't make any sense. They're not going to uphold that. And also, because the trustee can't sue themselves, it wouldn't make sense to make it also to uphold the bar of 25%, saying 25% of you have to say, I should sue myself before you can sue. So they throw out the no action clause defense. As to the breach of contract argument, they throw that out too. And they say, in this particular trust agreement, we're bound by the trust agreement language. And in this trust agreement, it gave the trustee the right to pursue a repurchase and replace remedy, but it didn't give them the obligation. It was a right, not a duty. And just because they have a right doesn't mean that if they fail to do it, they're breaching a duty. You can only breach a duty. That's what a breach of contract is, breaching an obligation, a duty. And because it was written in the clause in the contract as a right, then the breach of contract claims fail. And finally, as to the tort claims, they say, well, the question here, if the argument is that you breached the fiduciary duty and a conflict of interest, but because there was no duty, the question is, are these independent claims, or are these just piggybacking the breach of contract claims? And so they say there's a test here. The test is the plaintiff essentially seeking the same enforcement of the bargain as they would be under the breach of contract claim? And the 3-part test is, what's the nature of the injury alleged? How did the injury occur? And what's the harm that it caused? And if you go through those, they go through those factors and they say, this is really just a veiled breach of contract argument. They're looking for the same remedies, pursuing the same theory as breach of contract. They're just saying the reason why you breached the contract was because of conflict of interest and a breach of fiduciary duty. So that gets thrown out as well. I should note quickly in passing that Judge Wilson and Judge Troutman have dissents. They disagree with, Judge Wilson disagrees with dismissing the breach of contract claim. He says it should go to discovery. And Judge Troutman disagrees with dismissing the tort claim. She thinks that should go to discovery too. And that's the case of IKB International versus Wells Fargo Bank. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.